Welcome. In recent years, there has been ongoing talk in the media about the potential threat to India's secular values. As outlined in its constitution, India follows secular principles, while the state remains neutral towards religious affiliations and does not discriminate based on faith. However, some people, often described as liberal, argue that the current government favors the majority while neglecting the rights of the minority groups. On the other hand, some people suggest that secularism in India has typically favored minority communities over the majority. So, rather than getting into who is right or wrong, let's discuss these points using straightforward language and evidence. So, on today's video, I will analyze whether India is truly a secular nation or not. So, without wasting any time, let's get started. Definition of secularism. Secularism is most commonly thought of as the separation of religion from civil affairs and the state, and may be broadened to a similar position seeking to remove or to minimize the role of religion in any public sphere. The term secularism has a broad range of meaning, and in the most schematic and encapsulate any stance that promotes the secular in any given context. It may connote anti-clericalism, atheism, neutralism, non-sectarianism, neutrality on topics of religion, or the complete removal of religious symbols from public institutions. Secularism according to Indian Constitution. There is a clear incorporation of all the basic principles of secularism into various provisions of the Indian Constitution. Although the term secular was added to the preamble of the Constitution by the 42nd Constitution Amendment Act of 1976, emphasizing the fact that constitutionally India is a secular country which has no state religion, and that the state shall recognize and accept all religions, not favor or patronize any particular religion. While Article 14 grants equality before the law and equal protection of the laws to all, Article 15 enlarges the concept of secularism to the widest possible extent by prohibiting discrimination on grounds of religion, race, caste, sex, or place or birth. Article 16(1) guarantees equality of opportunity to all citizens in matters of public employment and reiterates that there would be no discrimination on the basis of religion, race, caste, sex, descent, place of birth, and residence. Article 25 provides freedom of conscience, that is, all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. As per Article 26, every religious group of individual has the right to establish and maintain institutions for religious and charitable purposes and to manage its own affairs in matters of religion. As per Article 27, the state shall not compel any citizen to pay any taxes for the promotion or maintenance of any particular religion or religious institution. Article 28 allows educational institutions maintained by different religious groups to impart religious instructions. Article 29 and 30 provide cultural and educational rights to the minorities. Article 51A obliges all the citizens to promote harmony and the spirit of common brotherhood and to value and preserve the rich heritage of our composite culture. Limitation of Indian secularism. Number 1. Even after 75 years of independence, the Indian state failed to implement uniform civil code for all citizens irrespective of his or her faith. Number 2. Hindus, Muslims, and Christians have different personal laws based on the religious law of that particular faith. Although Hindu personal law was modified by the government in 1956, number 3. Muslims have their own personal law board, and some of the law of this are discriminatory towards women. For example, polygamy is still allowed for Muslim men, and Muslim girls are allowed to marry under the age of 18. Number 4. Hindu temples are under government control, but that rule does not apply to other religious sites such as mosques, churches, and religious places of other faith. Number 5. The setting up of Waqf board in 1964 under the Waqf Act, which was passed in 1954, In 1995, by amending this act, the power of the Waqf board was significantly increased. In 2013, this act was further amended to give unlimited powers to Waqf boards to snatch away anyone's property which could not even be challenged in any court of law. Number 6. In the name of vote bank politics, many political parties appease particular faith for their political gain. Conclusion. Analyzing the essence of Indian secularism, it becomes evident that while the nation is secular by constitutional mandate, genuine secularism remains elusive. Some may argue that Indian secularism differs from its European counterpart. However, it's crucial to recognize that secularism itself is a Western construct. Before the advent of the constitution, India did not adhere to secular ideals. Nevertheless, India has a long history of embracing plurality and inclusion. Evident from ancient times, this historical openness facilitated the assimilation of various foreign invaders like the Greeks, Scythians, and Huns, etc. into Indian society. However, the Arab, Turk, or the European invaders with their distinct culture found assimilation more challenging due to their inability to integrate with existing societal norms. Therefore, India's path towards pluralism must align with its indigenous values, emphasizing diversity and mutual respect. This responsibility transcends any one community. Each must afford these principles. It's imperative to acknowledge that every Indian citizen, regardless of their faith, is entitled to equal constitutional rights. Granting preferential treatment to certain communities under the guise of false unity undermines true cohesion. Genuine unity can only thrive when all communities are treated equally, fostering a sense of belonging and shared prosperity essential for the nation's progress. Thanks for watching. Vande Mataram.